Violence Against Women and Their Children, or RA number 9262. This is part 1. We will be focusing on the basic concepts. Under the law, violence against women and their children refers to any act or series of acts committed by any person against a woman who is his wife, former wife, or against a woman with whom the person has or had a sexual or dating relationship, or with whom he has a common child, or against her child, whether legitimate or illegitimate, within or without the family abode, which result in or is likely to result in physical, sexual, psychological harm or suffering, or economic abuse, including threats of such acts, battery, assault, coercion, harassment, or arbitrary deprivation of liberty. There are 4 types of violence under RA 9262. First type, physical violence. These are acts that include bodily or physical harm. Type 2, sexual violence. Any act sexual in nature, including rape, sexual harassment, lasciviousness, treating a woman as a sex object, demeaning sexual remarks, prostituting the woman or child, and forcing the wife and mistress or lover to live in the conjugal home. Type 3, psychological violence. These are acts or omissions causing or likely to cause mental or emotional suffering, intimidation, harassment, stalking, damage to property, public ridicule or humiliation, repeated verbal abuse, marital infidelity, and witnessing sexual, physical, psychological abuse of a family member. Type 4, economic abuse, acts that make or attempt to make a woman financially dependent, withdrawal of financial support, deprivation of conjugal property, destroying household property, controlling the victim's money or properties. Who can be liable and who can be the victim? So RA 9262 was framed in gender-neutral terms, any act committed by any person against a woman who is his wife, former wife, etc. The court has consistently extended the law's reach beyond the husband's as offender model. So the offender can include in-laws covered when in conspiracy. If the husband acts in conspiracy with his parents-in-law to inflict acts of violence on his wife, the parents-in-law are equally liable under RA 9262, even though they have no dating or sexual relationship with the female victim. Lesbian relationships are also covered, as the law uses the gender-neutral word person. The offense may be committed by any person against a woman or her child. The use of person encompasses lesbian relationships. Mothers as offenders against own children. In the case penned by Justice Gerlan, Notson versus Honorable Sarmiento Flores, the mother abused physically her child. That prompted the filing of a petition for the issuance of temporary and permanent protection orders by the father. So one of the issues raised here is whether the father may file such petition under RA 9262 on behalf of his minor child against the child's mother. And the other issue is whether the law covers a situation where the mother is actually the offender, the one who committed violent and abusive acts against their own child. So the Supreme Court held yes as to both. The law expressly allows parents or guardians of the offended party to file a petition for protection orders. The statute used parents pertaining to both father and mother of the woman or child victim. So what the law does not distinguish, we should not distinguish. So the second issue, the statute uses the gender-neutral person, embracing any person of either sex. So the mother who maltreated her own child is not absolved from any criminal liability, notwithstanding that the law was intended to protect women and children. RA 9262 thus covers female offenders just as it covers male offenders.